This is Akashvani. 20th June is recognized as World Refugee Day. The theme for this year is Hope Away from Home. A world where refugees are always included aims to sensitize people about the struggles faced by refugees across the globe. It is against this backdrop that we now bring to you a talk entitled Refugees and Their Rights by Advocate Supreme Court of India Dr. Harsh Pathak.
After the birth of United Nations in 1945, the Universal Declaration of Human Rights was adopted by its founding members in 1948. It lays down the right that, quote, everyone has the right to seek and to enjoy in other countries asylum from persecution, unquote. In 1951, the Convention relating to the status of refugees, adopted by 146 countries, was the first international agreement for refugees' protection. The Convention defines the word refugees and lays down their rights in the context of the post-World War refugee crisis. Countries that have signed and ratified these conventions are prohibited from discriminating against and expelling the refugees. They are also not allowed to forcibly return refugees to their home country, a principle which is known as non-refoulement. In 1967, the protocol relating to the status of refugees, adopted by 147 countries, expanded the scope of international refugee laws beyond the World War II refugees of Europe and to include all communities forcibly displaced due to conflict and persecution. To further the mandate of the Convention and the subsequent protocol, the United Nations formed an agency in 1950 called the UN Higher Commission for Refugees in order to protect refugees and assist in their return, resettlement, and integration. Human rights of refugees are one of the major problems of the world. According to Article 1 of the United Nations Convention on the Status of Refugees, refugees are those who are, quote, owing to a well-founded fear of being persecuted for reasons of race, religion, nationality, membership of a particular social group, or political opinion, is outside the country of his nationality and is unable to or owing to such fear is unwilling to avail himself of the protection of that country, unquote. Although India is not the party to the 1951 Refugee Convention or its 1967 protocol, even do not have a national refugee protection framework, but still it continues to give asylum to refugees of the neighboring countries. Asylum seekers can get the refugee status from UNHCR if the status is not protected and provided by the legislation of the Government of India. Refugees are considered under the term alien in India. The term appears in the Constitution of India under Article 22, Section 83 of the Indian Civil Procedure Code, Section 32B of the Indian Citizenship Act 1955, as well as some other statutes. The difference between refugees and migrant is very important to appreciate. Refugees are people outside their countries of origin who are in need of international protection because of a serious threat to their life, physical integrity, or freedom in their country of origin as a result of persecution, armed conflict, violence, or serious public order. Whereas migrants leave their country because they want to work, study, or join a family. There are well-defined and specific grounds which have to be satisfied before a person can qualify to be a refugee. There is no internationally accepted legal definition of a migrant. The term refugee has a particular meaning in international law. It should be appreciated that a person becomes a refugee because of circumstances which are beyond that person's control. There are well-founded group of foreigners who are different from refugees. These categories are, number 1, temporary residents, tourists, and travelers. Persons under this category come to India for a specific purpose and duration with the prior permission of the Government of India. However, in certain circumstances, anyone in this category could become eligible for being a refugee if during their stay in India, the situation in India or the country of their origin becomes such as to endanger their lives and liberty if they were to return to their country. Second, illegal economic migrants. Any foreigner who might have left his or her country of origin without due authorization from the authorities concerned, both in the country of origin as well as the country of destination, solely to improve his or her economic prospect is not a refugee. After all, there is no element of persecution or coercion compelling the individual to leave the country of origin. Number 3, criminals, spies, infiltrators, and militants. None of these can ever become eligible to be refugees. They have to be dealt with under the provisions of the Indian criminal laws as well as any other special law in force, even though some of them may be in possession of valid travel documents. 4. Internally displaced person, also known as IDPs, those persons who are fleeing persecution and human rights violation from one region of the country and have sought refuge in another region of the same country, fall under this category. Such person cannot be categorized as refugees as they have not crossed any international border. Asylum seeking existing for many years, the early man used to migrate for finding food, shelter, and other resources. Around 600 AD, the right to seek asylum in a holy place or a church was codified in law by King Thalbert of Kent. But it was the 18th century when it was required for people to show ID verification to cross borders in many countries. The biggest refugee crisis occurred during the World Wars. The First World War lasted almost 4 years. 1 million refugees of Belgium went to Netherlands and thereon transferred to the United Kingdom and other countries similarly. France, Germany was also the worst affected. When Russia attacked Prussia, 870,000 people fled. World War II was one such war, which never happened in the history of the world. By 1959, some 900,000 European refugees were taken by European countries, and 461,000 had been accepted by the USA, and 523,000 by other countries. World War II caused around 60 million refugees in Europe itself. When we look into the history of refugees in India, it is evident by large-scale migration of people from different countries. These migrations has taken place in two ways. Firstly, Hindu Kush mountains in the west, and secondly, the Patkai range in the east. Since its independence, India has accepted various groups of refugees from neighboring countries, including partition refugees from Pakistan in 1947, Tibetan refugees in 1959, Chakma and Hajong from present-day Bangladesh in early 1960s, other Bangladeshi refugees in 1965 and 1971, Sri Lankan Tamil refugees from 1980s, and most recently Rohingya refugees from Myanmar in 2022. India has been the home to refugees belonging to all religions and sects, not only from some of its neighboring countries but distant countries like Afghanistan, Iran, Iraq, Somalia, Sudan, and Uganda. Constitution of India are applicable to the refugees when they are in India. The most important article is Article 21, which deals with right to life and personal liberty. It applies to everyone irrespective of whether they are citizens of India or not. Many judgments have been given based on Article 21 on refugees. Article 41 guarantees the person right to equality before the law. India does not have specific laws relating to the refugees, but the main legislations related to refugees are Citizenship Act 1955, Extradition Act 1962, Foreigners Act 1946, Illegal Migrant Act 1983, Indian Penal Code 1860, Passport Act 1967, Protection of Human Rights Act 1993, Registration of Foreigners Act 1939, Immigrants Act 1950, Administration of Evacuee Property Act 1950. At the same time, judiciary also plays a vital role in protecting refugees. They gave landmark judgments regarding refugees. The judiciary has made it easy with the concept of public interest litigation to protect the right of refugees in India. UNHCR, NHCR, and NHRC in India is participating very actively as the number of cases regarding refugees is increasing day by day. If some refugees goes back to his country after being a refugee period in India, UNHCR watches if the person is going back voluntarily. It performs the function of determination of refugees along with providing resources to them since the issue of Tibetan refugees and the Bangladesh crisis in 1971. As India has followed a liberal policy of humanitarian protection of refugees and asylum seekers, it is home to several groups of people who have come here and made it their home. The absence of refugee-specific legislation can be attributed to India's volatile situation in South Asian politics and the threat of terrorism faced by it. Despite that, India has addressed the needs of refugees through appropriate provisions and amendments in existing laws and thereafter effectively responding to the issues of refugees.
Refugees and their rights. You just heard a talk on this topic by Advocate Supreme Court of India, Dr. Harsh Pathak. This broadcast came to you over Indraprastha channel of Akashvani.